Hey, good day to you. Hey, this is Stan Prochowski with Prochowski Estate Law. This is the Ask Stan show every Thursday, live. Oh, looks like I just started. This is Stan Prochowski with the Prochowski Estate Law. Every Thursday at 12 noon, we do the Ask Stan show live on a Facebook feed. And today is June the 25th, 2020. Ask Stan. So, any questions? I'll be more than happy to answer them. If you got any posted, if not, I'll wait for a few. But meanwhile, I'll ask a couple questions that may have come in throughout the week. I did want to talk about one thing. Let me see if I can get this. So I can see your comments a little better. All right. So hey, here at Chelsea State Law, we write a lot of trust plans, do some wills. I'm a big trust fan, but when you do a trust plan, we have to name certain individuals. Now, I'm not talking about the people you name when you leave property to them. I'm talking about the people you name as like your successor trustee or the executor of the will, the people that are appointed to step into your shoes and conduct the final business or do what the trust says to do as far as distributing the property. So we name people. Usually you name a trusted family member like your child. You can name a sibling, something like that. It can be that way. But what I'm getting at is a lot of people I get only come up with maybe one person. And I have to really prod them to say, okay, if that person's not able or is unwilling or unable to serve, can we name someone else? And they get kind of stuck or just decide, well, I'm just going to name my oldest son and that's all. And I really advise people to name a couple in those capacities, or what I call Plan B. And it's necessary because, hey, everybody's family is dynamic, okay? Things change, and when you do a trust or a will, I get people come in here with trusts or wills that got 20 years of age on them. And, people pass away, people move to Europe, just become unavailable for these things. Or sometimes people change and just don't want the job. Or some of their circumstances change and makes them no longer an ideal person to be in that kind of a fiduciary position. So that's what I want to talk about. I want to bring up an example that came up that I thought kind of hit the nail right on the head. It's specific, but you'll get the idea. We like to keep up with what we call celebrity estates and stuff. Well, this is not a real big celebrity, but it's somebody you might remember. Years ago, the very first ever female Attorney General, United States Attorney General, was Janet Reno. That was some time ago. And, so she was relatively well-known and very accomplished person. Well, General Reno passed away in 2016, so about 4 years ago, November of 2016, and she had a trust. And I want to tell you a little bit about her trust because she had a piece of property that she grew up in with her mother down there in, I don't know the county, but it's right on the Everglades, so it might be Miami-Dade County, something like that. And my understanding was her mother pretty much built the little cottage with her own two hands. And so General Reno grew up there, and she often referred to that as, her inspiration and the launching point of her career. So it obviously had a lot of sentimental and personal value to her. And she had a trust plan, and she left that piece of property to the University of Miami. And she had conditions on it. And of course, those of you who've heard me talk about trust, when you leave property to will, you can't put any conditions on it. You can't tie any strings to it. With a trust, you can't. Well, she had a trust, and she did put conditions on it. The conditions were that they keep it up and preserve it as a historical piece of property, that sort of thing. It had historical importance. What she didn't do is, and then she left as successor trustee. She had a couple of brothers because General Reno never married, never had any children. So she named a couple of brothers who are in her basic age range, which it can be problematic. And sure enough for her, all her brothers, or all her siblings, predeceased her. Now that should have been a red flag that we need to go look at our plan, because when somebody predeceases you, let's face it, you know about it because you're around when they pass away. And you've named them in these important documents. And if they're not there anymore, if that's your first choice, you're already presented with your second choice, which may be a good time to go revisit your documents and re-up them and have them looked at. So they all predeceased, and who fell in secondary was she named her 7 nieces and nephews. Because remember, I said she didn't have any children. So one of her nephews was named James. His last name escapes me, but he was the successor trustee of it, and no problem. But here's what happened, which was kind of unique, is when he went to give it to University of Miami, this piece of property, with the terms and conditions of it being preserved for posterity and its historical value, University of Miami said, we don't want it. We don't want the gift. We're going to deny the gift because we don't want the obligation of preserving it to come with it. I mean, I can't hardly imagine that, but that's what they said. So now the trustee is kind of in a pickle because the trust did not have a plan B. Like if they don't want it, where's it go? I put this in all my trusts. It's even in the simplest form. It's like, okay, I leave my farm to my 3 children. I got 3 kids, so I leave it to my 3 children. If they predecease, then I leave it to their children. If they predecease, I leave it to their children. If I absolutely cannot find anybody to leave it to, I mean, if we exhaust all 3 kids and none of them have children, all those children predecease, you're getting pretty remote. But if everything fails and there's nobody for this to go to, then I name a remote contingent beneficiary, which is the Star Theater here in town, the nonprofit that Miss Tammy and I are heavily involved with, so that they get it. So I don't have a hole in my plan. There's always a place for it to go, because any place is better than the Department of Unclaimed Property. But here's what happened. She did not leave any other place for it to go. So the successor trustee, and I haven't seen the language of the trust, but somehow lacked the ability to use his discretion. So he went to court and said, here's what I want to do, and I want court approval. I want to leave it to the next best thing, or a similar organization. University of Miami said, we don't want it. So he went to the Miami-Dade College, another school, same area, and they were willing to accept it with the terms and conditions. But he felt like he didn't have the authority to change that, so he wanted to go to court, and the courts looked at it, and the court said, you know what, we're going to approve this decision because the trustor's intent is paramount, and since the University of Miami is not going to take it, that makes General Reno's wishes a legal impossibility. So this is really the next best thing that satisfies her intent just as closely as can be. So they approved him doing that. Well, as luck would have it, one of the nieces decided they wanted to challenge that and appeal it because they thought they'd be better off just selling it and getting the money. Okay, we're talking about nieces and nephews, so they really didn't have any understanding of the historical or sentimental value that General Reno had. They just wanted the cash, which is, you've seen it, you know what I'm talking about. You've seen it in other situations. Well, they appealed the decision. They were not successful, and the decision for him to give it to Miami-Dade College instead stood, and that's what he did. So what are the takeaways from this? The takeaways from this are, we got to have plan B, sometimes even a plan C. I often say, I'm in the what if business. So I'm going to say, okay, you want to leave it to your daughter? Great. What if she predeceases you? Okay, well then let's leave it to her children. Okay, what if she doesn't have any children? Or what if the children predecease you? Because accidents happen. Just because they're your children doesn't mean they're going to live to be a ripe old age and they're going to outlive you, right? I mean, let's get real. Accidents are the worst things to plan for because they could usually come out of nowhere. We all know we're going to get old and get sick and pass on someday, but we may not get sick, but we all know we're going to get old and die, but we don't know exactly when, but accidents are really a wild card. So, and don't let that worry you, because if you don't have a trust plan and you come to me and say, hey, Mr. Stan, I'd like a trust plan, I'll guide you through that process, and I'll say, hey, what if this? What if that? What if that? I'll give you the food for thought. You can think it through. And, if worst comes to worst, we'll go with some charitable organization. You certainly want to go to your family if you can, but if it doesn't, we can even use some generic terms that say if this gift lapses, it goes to any then living heirs of the trustors. I mean, I put that in all my trusts. So we can avoid what happened to General Reno in her trust, because she did not name where it goes if it doesn't go to who she gives it to. Because let's face it, you can't make somebody take a gift. I mean, that's a classic case. Now, I imagine if they just gave money, anybody would take that. I mean, who would turn that down? There's no conditions with it. or I guess there can be conditions with money, but I mean, who's going to turn down a gift of money? So, but giving the property and having to keep it up and stuff like that, they just didn't want the hassle. I get it. So if you want that, we need to have a couple alternative plans. So that's what I wanted to cover. People have asked questions about that when we put together plans, is what's the best way to do that. Now, what I want to, another takeaway from this I want you to know is that what if the, one of the kind of things would make you want to revisit your trust or your will or your plan and update it? Well, some of the classics are a marriage or the converse, a divorce. I mean, those are game changers, right? I mean, usually when you get a divorce, they're not too pleasant. And certain people you don't want to leave anything to anymore. And you're single now and you don't have joint property anymore because the divorce divided it up into separate property for each of you. You may have joint children and stuff, but you can leave to them, and the divorced spouse can leave to them on his own. So marriage and divorce is classic. Another thing, if people get sick, they get old, they get ill, going to the nursing home. If you've named somebody and they're now disabled or in a nursing home, they're not an ideal person to be put into this fiduciary position to conduct these things, right? So, and people, just like I said, predeceased. You'd be surprised how many people I get wills for and trusts for, and the people named in it died 10 years ago. Okay, I mean, it's not like we didn't know they died. We just didn't want to get around to updating it. If you do one of my trusts, I'll just throw this in there. If you do one of my trusts, I make updates and those kind of modifications at no cost. If it's one of my trusts, I'll update it for you. Because, we need it to work. That's the whole thing. A plan needs to work when it comes time to, and we know the things that make it not work, and we know the things that make it do work. And I pride myself in making sure that the plans that I do work when you need them, and I'll stand by that. And if they need to be updated, then I'll update it or I'll amend them for you. I don't even charge for that unless it's some really healthy amendment that takes a lot of time, energy, and effort, but they usually don't. It's just all part of the deal. So, all right, it's about 12 minutes after. I usually like to keep this trimmed at 10 minutes, 15 at the most. Hey, if you have a question, ask it. If you don't have one to post live, post it here on the Facebook page after you listen to this. I'll get to it. I won't wait till next Thursday to answer it. I mean, I'll send you an answer, but I might use it for next Thursday for a group question, if that's all right. Or drop by and see me here at the southeast corner of the square, or call me, 363-7222, and ask a question. I don't mind talking to people. I'll be glad to talk to you and get your question. So, hey, that's the Ask Dan Show for June the 25th, every Thursday at noon. If you have anything, get up with me. I've got some seminars coming up. I don't know if we nailed down the dates just yet, but I'll talk about them next Thursday. We just had one Tuesday, so we don't have anything planned. Had one Tuesday. It was how to not go broke in the nursing home. So if that interests you, get up with me because I got a free offer for you. I'll do an analysis for you. I call it ask for my property protection checklist. And I will do an analysis for you, show you what assets of yours I can save and how quickly I can save them from long-term health care. When you see what I can do, you will be absolutely amazed at what we can do. You'll be absolutely amazed. It'll blow your mind. So, hey, it's free. You want it? Ask for it and I'll do it. I mean, what do you got to lose besides everything if you don't protect it and go to the nursing home, right? All right, that's the Ask Dan Show. Thanks for attending. It's about 14 after. We'll see you next Thursday or when you stop in.